For the defense.
Tom Nisbet on behalf of Alfred Flores.
Mario Del Prado and Vincent Fuentes on behalf of Mr. Alejandro.
And Patrick Valentine on behalf of Nathaniel Villalobos.
All right, you all may be seated. And the reason why we're here today is there was a motion for continuance. The motion for continuance was denied, and the state wanted to change their oral agreement to try the defendants together. And the court informed all parties that if they wanted that to be heard, motions would need to be filed. So the court is in receipt of the motions. Defense, are you ready to proceed on the motions?
Yes, Your Honor. Did you get our response, Judge?
No.
Oh, we filed it yesterday, early afternoon.
All right. So other than your response, but you're ready to proceed on the state's motions? Defense attorneys?
Yes, sir.
Yes, Judge.
All right.
Your Honor, we have not had the chance to see what the response was. We'd like the opportunity to see it.
Oh, it was filed. I'm sorry. It said it was served. Here you go.
All right. So if y'all could do me a favor, do y'all have the same response in each case, or are there different responses from each defendant?
No, Judge, I believe it's going to be the same response agreed and joined amongst all parties.
All right. So yes, excuse me. Could you make a copy for me as well?
Yes.
All right, we're back on the record. The state, you filed a motion requesting severance. Is that correct?
Yes, we did, Your Honor. We
All right.
filed it on Tuesday.
All right, thank you. Oh, and all parties, you may remain seated. I find that it's easier for people to speak when they're seated as far as looking at all of the paperwork. So I don't take that as a sign of disrespect. And it actually makes it easier for the court reporter to hear. So if y'all will make sure you speak in the microphone so the court reporter can hear, that would be great. All right. State, it's your motion, so I'll hear your argument.
Good morning, Judge. Your Honor, we filed this motion out of concerns for there being the potential for prejudicial evidence against one defendant to come in against another defendant. We do not assert necessarily that they're improperly joined. Mr. Mulliner and myself, are at a disadvantage in that we weren't here for the prior hearings to know what was said and whether it was silently assented to by the state or agreed, or I don't know. The record will reflect what the record reflects on that. And I do not just disagree with the defense response in the sake of these cases cannot be joined together, because they can. Okay. What I'm here to bring forth to the court is it is the state's position there is great potential for a defendant or defendants to be prejudiced by going forward in this way. And I'll give a couple of examples. For example, each of the defendants gave a statement to the police, an interview to the state, and asserting different things about their role and their observations and what they heard and what they knew and what they understood. Right. And I understand that they've agreed to come together and have a unitary defense, but there are certain things that I can't believe will escape the evaluation by the jury, the arguments to the jury, or the explanations by the experts. And that's the fact that one of these individuals, Albert Flores, was a sergeant who was actually the supervising officer of Officers Alejandro and Officer Villalobos, who in the statements that he gave and in their statements that they gave talked about his supervisorial role in decisions and making strategic decisions about when to go forward and when to approach and whether they were going to enter. I don't know how much the facts the court knows on this case.
No, I will tell you, there have been no motions to suppress. So what I know about this case is what is in the indictment, and that is all.
Fair enough. And in the different roles that they served at the police department, I can't help but believe that at some point during trial that the other two defendants are going to point to Sergeant Flores and say, I was acting at his direction as my supervisor at the scene. It may be a secondary argument. It may be a third or additional argument or so. But it will certainly be one that will be made clear and in a sense then will create greater prejudice to Sergeant Flores as opposed to the other defendants.
All right, so let me pause you right there. Is that your first argument?
Yes.
All right, so let me pause you right there. Defense, do you want to address the state's first argument as to why this should be severed? And we're going to do one argument at a time.
Well, do you want, it's up to you, Judge, if you want me to wait until he's finished with all
No, no,
his
no.
points.
That's his first argument, is the fact that each of the defendants gave a statement. And here is one of my questions. So if everybody could focus in on this as well as the state's argument. If you have each party that gave a statement and that statement comes into evidence, is anybody going to raise any objections about, I can't really do anything with that because this person gave a statement? One of my concerns is lack of confrontation. So is anybody going to be waiving lack of confrontation if that becomes an issue with regards to the defendants? I think not.
No, Your Honor, because I don't know whether it's been filed yet or not, but as the court knows, this case is about 1.5 years old. Ever since its inception, we have relied on the state's clear waiver of any objection. Not that there's anything to object to because there's nothing prejudicial. We've relied on that. The courts relied on it. Apparently, the prior chief of that unit didn't see any issue with prejudice.
But no. Mike,
But yes, Your
no.
Honor,
Mike,
we're fine.
I understand what the defense argument is going to be,
Right.
but I want to focus right now on this one point that the state has made. In the motion that they have filed, they've made several reasons as to why it should be severed. So what I want to do is I want to give each party a time to make their arguments. So the state's first argument has to do with each of them giving statements, and that's going to cause concern. So I already read the defense's response. So I have an idea,
Sure.
but I want to take these one step
Sure,
at a
I
time
understand.
so we can address it.
That's why we have a joint defense agreement, Your Honor. I don't know whether it's been filed yet, so to reify the oral understanding, because I think the case law says we don't actually have to file one, but we have to let the court know we don't believe that there's any issues. And if there were potentially, those are waived. The argument about because he was a sergeant, that's going to become kind of obvious from the get-go that he was a sergeant and they were patrol officers. Part of the argument that he's trying to make now seems to be in contravention of Graham v. Connor, which is a U.S. Supreme Court case, which our own expert relied upon extensively in rendering his expert opinion. So that the tactics in this case should not be an issue according to their own expert. But there is no prejudice, and we will argue, Your Honor, as a matter of fact, there will be extreme prejudice if we are not allowed to be joined, and I'll address that. But as far as the argument that this speculation that because they all gave different statements, the statements are of one piece. It was one transaction, and we have no problem. All three defendants intend on testifying.
All right, so here's my question. You say that all three defendants are going to testify. What if during the trial they decide not to testify? You say that you all have a joint defense agreement. I'm assuming this is in the form of a written contract. Am I correct in that?
Yes, Your Honor.
All right, so what are the consequences if somebody violates that contract?
Well, the consequences would be, as the case law provides, that the court could at any time sever somebody out. But we're telling the court as officers of the court, if we're joined, I can't speak to separate trials, but if we're joined, all three of the co-defendants intend on testifying in support of one another, because in isolation, this story does not make sense. They absolutely have to rely on the other two to let a jury know in toto what the facts, and so that then the court can apply the law and they can apply the law to those facts.
But what happens if during trial, somebody decides on the advice of their counsel, because I'm assuming, even though you all have this joint defense, I'm assuming each attorney is looking out for the best interests of their client. And what if during the trial, a defense attorney said, yeah, I viewed this. My client doesn't need to testify. He's not going to testify. And what if during the middle of the trial, this joint defense agreement you have falls apart? The only consequences that you're telling me of that is severance. So that would mean that if your joint defense agreement falls apart, the consequence is we're going to have a severance in the middle of a trial. Oh, please remain seated. I'll hear for,
Yeah.
you can address, just be sure you state your name.
Ben Cifuentes, may I address the court?
Sure, have a seat at the table so the court reporter can hear you.
Okay. Your Honor,
These are
counsel,
just questions I'm asking.
counsel has posited a theory under their first reason, which is specious, and I'd like to address that because it might dispose of this issue as a specious issue. What they're suggesting is that my client, Eleazar Alejandro and Nathaniel Villalobos only acted under orders. That is a specious argument because I'm sure the court is very familiar with section 9.32 and 9.33 of the Penal Code. And the state throughout the entirety of this process has been under the impression that this is a civil rights case and that they exercised improper police authority. There is ample case law that from various circuits that whether or not an officer uses good or bad tactics, they always have the right to rely upon state statutes that provide them the right to defend themselves with deadly force or to defend third parties with deadly force. I don't want to preview the court with evidence, but I am sure that it'll be amply clear once the evidence is presented that all of the defendants acted in accordance with 932 and 933. Therefore, this specious argument that they're going to blame someone else for orders is a specious argument. And plus, the San Antonio Police Department General Manual 3.03 H and I says that if you are given an illegal order, you have the right to disobey. So it doesn't absolve the officers of responsibility if they were following an illegal order. So the argument is specious. They're required under SAPD Rule and Regulation 301 to know the laws of the state of Texas and the United States and to follow them. They're required by 3.28 to enforce the laws that they have been charged to enforce, and ignorance is not an excuse. So the argument that they're posing is a specious argument, and the defense that all of them have is the same under 932 and 933.
Okay.
Your Honor, may I just add one more thing?
Yes, and excuse me,
Okay.
just 1 second, everyone. Because we have more than one attorney, when you
Identify
all
yourself.
want to speak,
Okay.
please identify for the record.
Yes, Your Honor. Mario Del Prado from Mr. Alejandro. You know, in response to your question, Your Honor, the Aguilar case, which the state cited and the defense cited as well for a different proposition, is a Court of Criminal Appeals case from 2000. And in that case, you had a rogue co-defendant who, once they took the stand, started placing the blame on their co-defendant. The court talked about how joinder is encouraged and presumed, and severance is a rarity in these cases. The Court of Criminal Appeals said there was no misjoinder, there was no error, even in a case like that. That is, I assure the court, that is not going to be the situation here because we have a joint defense agreement. We have a consistent and unified theory of defense going forward for all of the officers. But even if the court is worried, there are actually, I could not find, and Mr. Valentine concurred with me, we could not find a single case wherein the state moved for severance. This is always something done by the defendants. And in this case, we are asking for joinder. We could not find a single case on that issue. And that's because under both the federal system and the state system, joinder is encouraged for a lot of the policy reasons that I talked about in my response.
All right.
Tom Nisbet, on behalf of all counsel and defendants, but specifically representing Alfred Flores, Judge, to just dovetail off of what Mr. Cifuentes was saying as well, an issue presented by the state that Mr. Flores in a supervisory role or sergeant role would create a conflict in the evidence. My argument additionally, or in the alternative to Mr. Cifuentes' argument, which I join in, is that there will be no evidence in this case that as a supervisor giving orders, Mr. Flores ordered anybody to draw their firearm and discharge it at or in the direction of Melissa Pettis, which every single count of every indictment deals directly with that actus reus, pointing and discharging a firearm intentionally or knowingly at or in the direction of Melissa Pettis. That's every count in every indictment. That's the burden they have to prove. That's the thing they have to prove. And there will be not one single piece of evidence in the record it will lay bare that anybody was ordered to pull, point, and discharge their firearm. Quite to the contrary, the evidence will show that it was a non-deadly force plan
Right.
using only non-deadly force implements and had nothing to do
So
with firearms.
here's the court's question for the defense. If your joint defense agreement falls apart, you're saying the consequence would be during trial, a severance. Am I correct? And that's what I heard. Is that
Claudio
correct?
Del Prado again, and then I'll let I know Mr. Valentine's wanted to respond. I am saying that if the joint defense agreement fell apart, the court could continue the case. The case law says there is still no misjoinder. The case law talks about antagonistic defenses are not grounds for misjoinder. Commenting on the other defendants remaining silent is not grounds for misjoinder. There are absolutely no grounds for a severance in this case, even assuming the court's scenario. The court could continue, and per the Court of Criminal Appeals and the U.S. Supreme Court, there would not be any error. And now I'll let Mr. Valentine respond, Your Honor.
Judge, I'm going to try to resolve your concern directly. On behalf of defendant Villalobos, we are affirmatively waiving any objection on confrontation grounds or hearsay grounds for that matter with regards to the statements of his co-defendants. We
All
are
right.
waiving that in, I'm sorry. go
Just
ahead.
1 second. So he says he's waiving that. Any other defense attorney for their
Claudio Del
clients?
Prado for Mr. Alejandro, we would do the same.
All right,
And that
and
was the purpose of the joint defense agreement.
let's do that. But say what it is on the record that you are waiving.
We would affirmatively waive any confrontation arguments with regard to the other co-defendants, Your Honor.
And so that the record can be clear, that is at trial as well as if this were to be appealed. Is that correct?
Well, there's only confrontation rights at trial, is my understanding, but sure, I mean, the appeal is going to be controlled by what happened at the trial.
Well-
And we are waiving any confrontation at the trial. We're doing it here on the record. Yes, Your Honor.
Well, and the reason why I say that, because if someone were found guilty, there are many arguments that can be made that's related to the waiver of confrontation. And that would be a linchpin for whatever argument a appellate attorney would make. The fact that defense counsel waived confrontation and therefore this is what we're arguing. But who are the other persons, if you'll announce, are you waiving?
Yes, Judge Tom Nisbet, on behalf of Alfred Flores, we join in the waiver on behalf of Alfred Flores, specifically of the confrontation clause and hearsay objections as it would pertain to joined co-defendants Elazar and Villalobos at trial.
Thank you for putting that so succinctly. I like that. All right, Mr. Valentine, you were still making your argument?
Well, I mean, if that satisfies the court's concerns on that particular issue, then I guess I'm done.
All right. And then defense, it's your motion, so you can address that one point, then we'll move on to your next point.
This is David Lonan for the state again. Your Honor, I think that's a necessary component of it going through trial, that they are willing to waive the confrontation rights, meaning that any statements made by either of their clients, whether it's in a formal statement given to an investigator or statements they made at the scene that are on body camera and those kinds of things. It would be admissions to party opponent by the state if we were trying them individually, would also be waived, confrontational rights. Is my understanding from what they've assented to.
All right. All right.
I see nodding, but I want to be sure that that's clear.
All right. So
Okay.
you have heard what State's Attorney Noonan has said. Attorneys, is that clear? State your name, who you represent, and say, yes, that's clear, and that's your agreement.
Tom Nisbet, representing Alfred Flores. I'm nodding affirmatively. My answer is yes.
Mario Del Prado for Mr. Alejandro. My answer on behalf of Mr. Alejandro and Mr. Cifuentes is yes.
And Patrick Valentine, on behalf of defendant Villalobos, our answer is yes.
All right, State.
And then furthermore, Your Honor, to protect any claims against ineffective assistance or so, I would like the defendants, having understood the potential conflict, it's their right to waive, not their lawyers, if they would agree to waive those rights that they have to confrontation at a joint trial for the reasons we've described.
I'm going to give the defense attorneys a moment to talk to their clients about that. And if it comes that you all are in agreement with that, I will swear them in for the sole purpose of answering that question. So we'll take a short recess so you all can discuss the consequences with your client, and take as long as you need to take to discuss that with them. And if you all want to do it separately, which I would suggest doing it separately, then you all can come together and do it together. That way, each defendant will have a chance to speak with his attorney without the other attorneys present.
Yes.
And if you all need different rooms, the jury room, Deputy Laura can open it, and that's a bigger place for you all. So we're back on the record. So with regards to your joint defense agreement, are you all tendering a copy of that to the state or no?
Judge,
Oh, please remain seated.
I'm sorry.
Oh, it's fine. And the only reason why I bring that up is because where we left off before parties left the room, it appeared that the defense maybe was going to give the agreement. I know an attorney had said that an agreement had been filed with the court, but I don't have a copy of any joint defense agreement.
So in consultation with my betters, the agreement itself, we believe, is work product. Well, what we will file is a notice of a joint defense agreement with the court, putting it on the record and giving all parties notice that there is a joint defense agreement. But the agreement itself is a contract between the parties, which I don't think can be compelled to be disclosed.
Oh, I'm not compelling anything to be disclosed. My thing was that it appeared that someone stated that it had been filed. I was not in receipt of that. And as you know, Odyssey, there are some issues with that. So I was thinking maybe it was being lost in the system. And correct me if I'm wrong, but then the state said, we haven't received a copy of that. Can we get a copy? And then that's when everybody left for discussions. So what I'm understanding from all defense counsel is that the joint defense agreement, the contents of it, you will not be placing that on the record, and you will not be giving a copy of that to the state or the court. Is that correct?
That's correct.
Right. So the only thing you would allow to be known is the fact that there's a joint defense agreement between the defendants. Is that correct?
That's correct. And I can file that along with, and I can throw in language about waiving confrontation, just so we're absolutely clear on that point.
All right. State?
Yes, Your Honor. You know, our purpose in filing this motion was twofold. One, to ask the court in her discretion to reconsider this decision to join these cases together because of the hazards.
Yes, and I'm sorry to interrupt you
Yes.
for just a moment. So the defense counsel went outside to discuss with their clients about placing something on the record with their clients being called as witnesses. Defense, you've had a chance to speak with your clients, is that correct?
Yes, Your Honor. Ben Cifuentes for Alejandro Eleazar. I have spoken to him. He's ready to testified to the limited purpose for which the court excuses.
All right, so then the first thing we'll do is we'll call your client as a witness. The only questions that will be allowed will not be about the facts of the case. It's only about this issue as it relates to whether or not the court should be granting a severance or not. Does everyone understand? And if anybody feels as though questions are being asked that are going into perhaps the facts of the case, object. So if you have your client come forward, and if the counsels will come forward with their client, please. And we'll just do one accused at a time. Good morning. All right, could you raise your right hand for me, please? Do you solemnly swear and affirm that the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, and if you will state your name for the record. All right, defense.
Mr. Alejandro, we have talked about the issue of severance in this case, have we not?
Yes,
And you understand what severance is?
yes,
And is it your desire to proceed with trial with the other two defendants, Nathaniel Villalobos and Alfred Lewis?
yes,
And you understand the issue raised by the state that there could be a potential issue of confrontation if should one or more of the defendants not testify?
yes,
And understanding that, you still wish to proceed with a joint trial?
yes,
All right, and if you could also address with him, not the substance of the joint defense agreement, but the consequences if either defendant decides to violate that agreement.
Did you sign a joint defense agreement today that was in writing?
yes,
And did that joint defense agreement set forth the consequences or the obligations of whoever decides to withdraw from that agreement?
yes,
And knowing what the consequences are, do you still wish to proceed with the joint trial?
yes,
And again, I'm not trying to get involved in your agreement, but what are the consequences? I know we discussed this with the state and the defense attorneys, but what is the consequence? And is he aware of the consequence?
Understand that should there be withdrawal, that you are waiving any potential error at trial or on appeal?
yes.
All right, state questions.
Mr. Alejandro, I'm in a position like see, right? Do you understand what your rights of confrontation are? Yes. Do you know what is meant by that? Yes.
Excuse me, counsel, you're blocking the court reporter. Okay, thank you.
And it's a right that's yours. Not Mr. Fuentes, not Mr. Del Prado. It belongs to you. You understand that, right?
Yes, sir.
And you're willing to waive those rights to confront witnesses against you as it relates to the other people that you're charged with, Officer Villalobos and Officer Flores.
Yes, sir.
Right? And you recognize that if your remedy in your joint plea agreement that someone maybe fails to go through with what's agreed to in the joint plea agreement, that remedy isn't necessarily anything that's guaranteed from the judge. Do you understand that your rights to get a severance during the trial is dependent on the judge, not dependent on your agreement?
I object to the form of the question. He used the word, that phrase, joint plea agreement.
I'm sorry, joint defense agreement. Do you understand that whatever remedies in the joint defense agreement is not enforceable upon the court? Yes. And you recognize that if you're in trial, okay, and it's going in a way that you feel like it's not going well, and your lawyers in discussing about how it's going don't feel that it's going well for you, and you want to do something different from the defense agreement, or you find new evidence that you think that you are now not able to offer in light of the fact that you are being tried with two other people with confrontation rights against as it relates to other witnesses, that you don't automatically get to say, I demand a motion severed.
I object to the question as compound and also it tends to invade the attorney-client privilege.
All right,
I'll
That-
react.
yes, if you can, I'll sustain with regards to compound.
And Your Honor, the point I'm getting at, so I can kind of express my question properly, is if the defendant is aware of a potential conflict now and still seeks to be joined together with the co-defendants, and knowing that he should not be entitled to sever the case if that issue should come up at trial. I wanted to be sure that he understood that if that becomes a problem at trial, you have no right to sever.
Again,
Do you understand that?
I object that it tends to invade the attorney-client privilege and it's repetitive.
All right, so here's my question for defense counsel. If the joint defense agreement is violated, does your client also waive a request for severance during the trial?
Yes. Yes.
All right, and if you will question the witness about that.
Do you understand, again, that's an important right that you have, right?
Yes, sir.
A right to not be tried in the same proceeding as other individuals if it can result in prejudice to your harm to your case,
Yes, sir.
right? But by your words, by your attorney's words, you're willing to waive that as well in order to keep this joint trial together and not be segregated or separated from them.
Yes, sir.
I'm satisfied.
All right, defense, any other questions? All right, thank you. All right, who's the next attorney? All right, good morning. Can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand if you'll state your name for the record, please. All right, defense.
Thank you, Judge. Alfred, we spoke prior to getting back on the record in this case about your confrontation clause and rights to object under hearsay and rules of evidence admissibility to Paul, correct? You mind if I leave? Please. Okay. And is it your testimony before the court now that at trial you are waiving, at trial and appeal, you are waiving your confrontation clause and admissibility objections as it pertains to the statements and testimony of Mr. Villalobos and Mr. Alejandro? That's correct. Okay. You understand that those would be appellate issues that would normally be reported to a defendant, but you are knowingly and voluntarily waiving them on the record under oath before the court here presently? Yes. Okay. Are you seeking to waive any objection or any desire to seek a severance mid-trial should you change your mind?
I'm sorry, I didn't hear his last answer.
Sure.
All right,
Pass the witness.
I'm satisfied.
all right, thank you.
Thank you. Thanks, sir. Three?
You did a great job.
Yes. All right, and the next accused.
Edward Valentine for Nathaniel Villalobos.
All right, can you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right.
Mr. Villalobos, we had a discussion previously, just a few minutes ago about this particular issue you're going to be testifying about, right? Yes, sir. In that discussion, we talked about how you have a right to confront the witnesses the state brings in against you. Do you remember that? Yes. And what that entails is we have a right to demand that the state bring in those actual witnesses rather than putting in their statements generally. You understand that? But with regards to your co-defendants, in this case, you are waiving the right to confront those witnesses, meaning those statements could come in and you couldn't make a constitutional confrontation objection. Do you understand that's what you would be waiving? Yes, sir. Okay. And do you understand because you're waiving that, you would not be able to raise that issue on appeal?
Yes, sir.
Do you agree with me that that's a matter of trial strategy that you're sending?
Yes.
I think that's absolutely.
And just the additional point, do you agree to waive the right to seek a severance mid-trial if things are not going in the way that you anticipated in relation to the defense agreement?
Yes.
All right, thank you. All right, so defense attorneys, if I could have one more thing on the record before the state continues their argument, if they wish to continue to argue requests for severance. So it's the court's understanding, and if I'm wrong, please let me know I'm wrong. It's the court's understanding that it is the defense attorneys and their clients' trial strategy to proceed to try these cases jointly. Is that correct, defense?
Alfred Flores, Tom Nisbet, yes.
Ben Cifuentes for Eleazar Alejandro, yes, Your Honor.
Patrick Valentine for Nathaniel Villalobos, yes, Your Honor.
Thank you. All right, so state, do you wish to continue with your motion?
Given the waivers that have taken place, Your Honor, we no longer urge our motion.
All right, the state is withdrawing their motion. Any objections to the state withdrawing their motions? Defense?
Alfred Flores, Tom Nisbet, no.
Ben Cifuentes for Eleazar Alejandro, no, Your Honor.
Patrick Valentine for Nathaniel Villalobos, no, Your Honor.
All right, we can go off the record. So how long do y'all expect this jury trial to last?
Your Honor, I don't know how many witnesses the state's going to put on.
Well, for the defense, and I'm not holding you all to a time limit, but defense, if you're planning on calling witnesses, how long do you expect your case to last?
I think it's conceivable that our witnesses could be 1 week.
Okay.
But we know that the court has ruled on Monday.
Mhm.
And we would like to re-urge that with all respect to the court, re-urge it and also articulate with greater specificity for the record. And then I know the court has ruled, but I want to articulate with greater specificity some of the reasons. The court had asked me questions about dates, and I have those dates now.
All right, so as you all know, I like for motions to be filed. So you can file your request, and then we will have the hearing. Let me look at the calendar. If you all can file your request today, we can have the hearing today. Will it take you a while to file that today?
I can confer with my co-counsel. I think that I could do that, but I don't know. I don't want to speak for my co-counsels.
All right, if you all can file it today, we can have the hearing today. If there is no objection from the state?
We'll be here, Your Honor.
All right, and if not, then the next date that we can actually have this for hearing will be September 9th.
Okay.
I have medical issues I need to take care of the week of September 2nd, so.
I understand, Your Honor, and that's perfectly understandable. And I anticipate having something e-filed today. I just think that an abundance of caution, if it's acceptable to the court.
Well, if you all have, if there is no objection from the states, I know motion should be sworn to. If there's no objection from the state to waiving it being sworn to, if you all have your computers with you, if you all want to fill it out and just email it to the court coordinator and she can print it out and give the state copies, and then we can hear it. But if you all want to do it at a different time, we can do it at a different time.
I would prefer, if it's okay with the court, to go back to my office and be meticulous, so there's no doubt.
Okay.
And if it's acceptable to the court, I'd like to have a hearing next week.
All right.
I was thinking next week wasn't available to you, but
No,
that's
that's
agreeable.
not the week of September 2nd. Well, let's do this. I will tell you September 2nd. Let me see.
And I too have medical appointments on the 4th, so.
All right. So I will be able to do it on September the 3rd, but it'll have to be at 9 a.m. That's the earliest I can, well, that's the latest I can do it that week.
I think that would be fine with me if it's okay with everybody else.
Works for the state, Judge.
Okay. All right. In defense, since it's just for a motion for continuance, your clients can appear in person or they can appear on Zoom. I don't know if they have employment or if they're currently employed. If they are, they can appear by Zoom instead of coming down for a motion for continuance if there's no objection to them appearing by Zoom.
No objection.
All right, so then if we do it on September 3rd, I'll need everyone here at 9
Very well, Your Honor.
because that will give me a chance to do the other things that I need to do.
I appreciate that, Your Honor.
All right, you're welcome.
Just as housekeeping, since it seems like the normal certificate of service might not be coming to us, could they just be emailed to us? You're always very good about that, Ben, for sure. So just continue with that practice.
All right,
Thank you.
will
All
do.
right, and bring me a copy, please.
I will, Judge.
All right, thank you. Is there anything else?
No, Your Honor.
All right, everyone have a safe weekend.
May we be excused?
Yes,
Thank you, Your Honor.
you're welcome.
Thank you, Your Honor.
Welcome.
Hey, lady, get over here. Get over here. You're gonna get
You ain't got no work.
door.
No.
Hey.
Hold on.
You ain't got no work.
Let's go. Move.
Go, get him. Hey, what's up?
Hey, watch out.
Hold on.
You ain't got no work.
Oh, okay, watch out. Watch out. Go, get him. Hey, what's up?
Hey, watch out.
Hey, so if we have all this evidence,
Get up.
B, hold on.
You ain't got no work.
Go, get him. Hey, what's up?
Hey, watch out. Hey.
Back up.
Hold on.
You ain't got no work.
Go, get him. Hey, what's up?
Hey, watch out.